I'm going to leave it up to you. Your lunch is here. I don't know if you want to break for lunch. It'll take me about 20 minutes to read the jury charge, and then you can just want me to go ahead. All right, we're going to hand out the jury charge, and then in the criminal court of Davidson County, Tennessee, Division 6, State of Tennessee versus Travis J. Reinking, case number 2019-A-55, charged to counts 1 through 4, murder in the first degree, and counts 13 through 16, murder in the first degree, fixing punishment at life imprisonment or life imprisonment without the possibility of parole. Members of the jury, you have found Travis J. Reinking guilty beyond a reasonable doubt of premeditated first-degree murder as charged in counts 1 through 4, and first-degree felony murder is charged in counts 13 through 16 of the indictment. By operation of law, counts 1 and 13, counts 2 and 14, counts 3 and 15, and counts 4 and 16 are merged into singular convictions for punishment purposes. The evidence in the punishment phase has been completed. It is my duty now to instruct you as to the law. The law applicable to this punishment phase is stated in the instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Opening statements, closing arguments, and remarks of counsel are intended to help you in understanding the evidence applying the law, but they are not evidence. If statements were made by an attorney that you believe are not supported by the evidence, you should disregard them. This principle also applies to alleged statements or alleged facts suggested by an attorney in a question presented to a witness. Therefore, an alleged statement or alleged fact suggested in the question is not evidence and should be disregarded unless the witness agreed with the statement or fact suggested in the question. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for these offenses. Tennessee law provides that a person convicted of murder in the first degree shall be punished by imprisonment for life without parole, possibility of parole, or by imprisonment for life. The defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt phase, finding phase, the sentencing phase, or both. You are the sole judge of the facts and of the law as it applies to the facts in the case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judge of the law as well as the facts under the direction of the court. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness is sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof if any of his or her general character, the evidence if any of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters if any are shown, and all the evidence in the case tending to corroborate or contradict him or her. Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. Prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, and physical effects of the victim's deaths on the members of the victim's immediate family. You may consider this evidence in determining appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant and not an emotional response to the evidence. Victim impact evidence is not the same as an aggravating circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. Statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1, the defendant knowingly created a risk of death to 2 or more persons other than the victim's murder during the act of murder. 2, the defendant committed mass murder, which is defined as the murder of 3 or more persons, whether committed during a single criminal episode or at different times within a 48-month period. You shall not consider any other facts or circumstances as aggravating circumstances in deciding whether imprisonment for life without the possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, you shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but not be limited to the following. 1, the defendant has no significant history of criminal activity. 2, the murder was committed while the defendant was under the influence of extreme mental or emotional disturbance. 3, the murders were committed under circumstances which the defendant reasonably believed to provide a moral justification for the defendant's conduct. 4, the capacity of the defendant to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law was substantially impaired as a result of mental disease or defect or intoxication which was insufficient to establish a defense to the crime, but which substantially affected his judgment. 5, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. Verdict, life imprisonment or life imprisonment without possibility of parole. If you unanimously determine that the statutory aggravating circumstance or circumstances have been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without the possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravating factors proven by the state beyond a reasonable doubt and any mitigating factors raised by the evidence. In your verdict, you shall reduce to writing the statutory aggravating circumstance or circumstances so found, and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. You can have no prejudice or sympathy or allow anything but the law and the evidence to influence your verdict. You must render your verdict with absolute impartiality as you think the law and the evidence require. The verdict must represent the judgment of all 12 jurors. It must be unanimous. As jurors, it is your duty to consult with one another and to deliberate with a view to reaching an agreement if you can do so without surrendering your individual judgment. Each of you must decide the sentence for yourself, but do so only after impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your views and change your opinion, but do not surrender your conviction as to the weight or the effect of the evidence solely because of the opinion of the other jurors or for the mere purpose of returning a verdict. When you have reached a verdict as to the punishment to be imposed, you will return to this courtroom to announce your verdict on the verdict form provided. The verdict form provided reads as follows. In the criminal court for Davidson County, Tennessee, Division 6, State of Tennessee versus Travis J. Reinking, case number 2019-A-55. Punishment for imprisonment for life without possibility of parole or imprisonment for life. We, the jury, unanimously find the state has proven the following listed statutory aggravating circumstances beyond a reasonable doubt. There are 2 listed. There's a blank. You can check the ones that you find beyond a reasonable doubt. And those 2 aggravating circumstances are the defendant knowingly created a risk of death to 2 or more persons other than the victims murdered during the acts of murder. The other one is the defendant committed mass murder, which is defined as the murder of 3 or more persons, whether committed during a single criminal episode or at different times within a 48-month period. Therefore, And then again, there's two options. You will check one. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without the possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. This verdict form, unlike the other one on the guilt or innocence phase, must be signed by each of the 12 jurors who deliberate on this particular issue. And then it will be brought back as already indicated and read in open court, which will then become the judgments as it relates to the, yeah. Yes. Or judgment forms, one for each of the victims that was murdered as a result of this trial. So you'll end up getting 4 and you'll have to sign all 4 of them. All right? Anything else? You can step on back.
Take this back and give it to
Yeah.
Court's in recess.